This is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And today we're diving into constitutional law. Specifically, episode 19, focusing entirely on the Fourth Amendment.
That's right. And, this podcast is made possible by the magic of AI and really by Angela's fantastic constitutional law notes.
Absolutely. They're the foundation for everything we discuss here.
Indeed.
Yeah.
And Angela, well, she's the driving force behind this whole series. She's a student over at George Mason University.
And she's putting her knowledge to work already. Angela works as a freelance remote law clerk.
That's right. So if you happen to be an attorney listening and you need a hand with, say, LexisNexis or maybe some in-depth legal research.
Or writing appeals, motions, complaints, that sort of thing.
Yeah, or even getting your office set up with AI tools, which is pretty cutting edge.
You can reach out to her directly. Her email is hello@legalwriterandlawclerk.com.
And for any general questions about the podcast or other ways to contact Angela about this series,
the email is podcast@studyforthebarinyourcar.com.
it really is a passion project for her.
Yeah.
And you can tell from the quality of the notes.
Okay, let's get started. The Fourth Amendment, it's fundamental, really, to American liberty.
Absolutely. It's all about protecting us from, well, unreasonable government intrusion.
To really get it, we should start with the text itself. It's short, but wow, it packs a punch.
It does. Here's the full text, straight from Angela's notes. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
So right off the bat, the core idea is protection against unreasonable government searches and seizures.
Exactly. Think of it as like a shield. The government can't just barge into your life or your home whenever they feel like it.
The default rule, and Angela's outline really hammers this home, is that the government generally needs a warrant signed off by a judge to search your stuff or arrest you.
Right. If they do it without a warrant, the search or seizure is considered per se unreasonable, automatically unreasonable, basically, unless one of those specific, well-established exceptions applies. And the government has to prove the exception fits. It's a high bar.
Okay, and this is a really important point, one that often trips people up. This amendment only limits the government.
Right. Federal, state, local government actors.
Yeah.
Not your neighbor, not your boss at a private company, unless they're acting for the government, like as an agent.
So your landlord searching your apartment might violate your lease, but probably not the Fourth Amendment itself?
Generally, no. But if the police ask your landlord to search it for them, then it becomes a government action and the Fourth Amendment kicks in.
It's about checking state power.
Precisely. And Angela's notes bring up a good case here. Ontario v. Kwan?
Oh, yeah, the pager case.
That's the one. A city government, acting as an employer, looked at text messages on pagers they gave to their police officers.
And the court said?
The court said it didn't violate the officers' Fourth Amendment rights in that context. The key wasn't zero privacy, but that the city was acting like an employer managing its equipment, not just like law enforcement digging for crime evidence in a purely private space.
So context is everything. Employer role versus police investigation role.
Exactly. Which leads us to another tricky area Angela highlights, public schools.
Ah, yes. The constant balancing act between student privacy and school safety.
It's a tough one. Schools sometimes search lockers, backpacks, cars on school property. They might do drug tests or use drug-sniffing dogs.
And the courts have to weigh the school's need to keep order and safety against the students' Fourth Amendment rights, which are, somewhat lessened in the school setting, but definitely still exist.
Right. The reasonableness standard gets really nuanced there. It's not quite the same as a street encounter or your home.
Okay, so we know who it applies to the government. And the general idea, protection from unreasonable intrusion. But what counts as a search? Because it wasn't always about privacy, was it?
No, not at all. Originally, Angela's notes point out it was very physical. Like, did the police physically trespass onto your property? Did they physically rummage through your pockets?
A real bricks and mortar kind of view.
Exactly. But then came the huge case, Katz v. United States, back in '67. Angela's materials mark this as a total game changer.
This is the phone booth case, right?
That's the one. The FBI bugged a public phone booth Katz was using. They didn't physically go inside the booth while he was there, but the court said it was still a search.
Why? What changed?
Katz shifted the focus from physical places to people's privacy. It introduced the idea of a reasonable expectation of privacy.
So it's not just about physical space, but about what you reasonably expect to keep private.
Precisely. If you have that reasonable expectation and the government intrudes on it, that's a search, even without a physical trespass. It protects people, not just places.
That's a massive shift. So where do we generally have this reasonable expectation of privacy? What areas get the most protection, according to Angela's notes?
Well, number one, hands down, is the home. Your house, your apartment. It gets the absolute highest level of Fourth Amendment protection. It's your sanctuary.
And that includes the area right around the house, too, doesn't it? The curtilage.
Yes, exactly. The curtilage. Think of your porch, maybe a fenced-in area immediately adjacent to the house, the walkway up to the door. It's treated like part of the home for privacy purposes.
Implied by the contrast with open fields, which we'll get to.
Right. Other places usually include hotel rooms. Once you check in, it's temporarily your private space. Offices, especially private ones, even your luggage. Places where you normally expect privacy.
And speaking of the home, Angela's notes mention Stanley v. Georgia. That case really drove home the privacy aspect, didn't it?
Oh, absolutely. Stanley is fascinating. The court basically said the government can't police what you read or possess in the privacy of your own home, even if it's obscene material.
With a major exception for child pornography, of course.
Of course. But the principle was powerful. Your home is a zone of private thought and possession, largely off limits to government control. Huge protection for home privacy.
Okay, so if those areas are protected, what areas aren't? Where does that reasonable expectation of privacy disappear?
Well, generally, anything you knowingly expose to the public. If you leave something out on your front lawn where anyone walking by can see it, you don't have a reasonable expectation of privacy in it from, say, police observation from the sidewalk.
Makes sense. What about those open fields you mentioned?
Right, the open fields doctrine. Angela's notes cite cases like Hester and Oliver. Basically, areas outside the curtilage, even if they're on your private property, don't give Fourth Amendment protection.
Yeah, so my sprawling back 40 acres, even if
Exactly.
fenced with no trespassing sign?
Generally, yes. The police could potentially walk onto that land or fly over it without it being a search under the Fourth Amendment. The idea is those areas aren't intimately tied to the privacy of the home itself.
Okay. And related to things being visible is the plain view doctrine.
Yes, another crucial concept and an exception to the warrant rule.
As I recall from Angela's materials, 3 things need to be true for plain view seizure. 1, the officer has to be lawfully present where they see the item.
Check. They can't trespass to get the view.
2, they need probable cause to believe the item is contraband or evidence of a crime.
Right. It has to look illegal.
And 3, the illegality has to be immediately apparent. They can't, like, pick it up and inspect it to figure out if it's illegal.
Exactly. It has to be obvious just by looking. Angela's notes use Arizona v. Hex to illustrate this perfectly.
The turntable case.
That's it. Officer sees nice stereo equipment, suspects it's stolen, moves a turntable slightly to see the serial number.
And the court said?
Nope. That little movement was a separate search. The serial number wasn't in plain view. The court said, a search is a search, even if it happens to disclose nothing but the bottom of a turntable. Any manipulation to see something hidden blows the plain view doctrine for that hidden part.
Wow. Okay, so that clarifies plain view. Now let's get back to warrants. Generally required, but what makes one valid?
Okay, several key requirements for a valid search warrant. First, and most importantly, probable cause.
Define probable cause for us again.
Angela's notes define it as evidence that would lead a person of reasonable caution to believe that evidence of a crime will be located in a particular place to be searched.
So more than a hunch, but not necessarily certainty, like a fair probability.
Exactly. It's a practical, common sense standard. More than reasonable suspicion, which we'll get to with Terry stops, but less than proof beyond a reasonable doubt needed for conviction. Maybe think, like a substantial chance.
Can you give us that example from Angela's notes, the undercover buy?
Sure. Undercover cop sells, say, counterfeit money to Mr. X in a park. They see Mr. X put it in his car and drive off. The officer immediately goes to a judge.
Is there probable cause to search the car?
Absolutely. Based on the officer's direct observation of the crime and seeing the evidence go into the car, there's a very strong, reasonable belief, probable cause, that the counterfeit money is in Mr. X's car.
Clear example. What else does a warrant need besides probable cause?
It needs particularity. This is huge for preventing general searches.
Meaning?
The warrant must specifically describe the place to be searched. Not just a house on Elm Street, but 123 Elm Street, the single-family residence.
And the things.
And the persons, or things to be seized, not just illegal stuff, but cocaine, scales, packaging materials, and records related to drug trafficking. It has to be specific based on the probable cause shown.
Prevents rummaging, basically.
Exactly. And then there's proper execution. While Angela's materials don't detail this extensively here, it means officers have to execute the warrant within the scope allowed, within the time limits, usually during the daytime unless specified otherwise, and so on.
And if there isn't a clear rule for a certain type of search, how do courts decide if it's okay?
Then it comes down to reasonableness. This is the ultimate touchstone of the Fourth Amendment. Courts balance the degree of intrusion on the individual's privacy against the government's legitimate interests in conducting the search.
It's a balancing test. Angela's notes mention Chandler v. Miller and Terry v. Ohio here.
Right. Chandler said searches usually need individualized suspicion. You need a reason to suspect this person. But it allowed for exceptions based on special needs, beyond normal law enforcement, like certain safety regulations. You still balance the interests.
And Terry.
Terry v. Ohio is foundational for street encounters. It said reasonableness depends on the specific situation. Would a man of reasonable caution believe the police action was appropriate under the circumstances? This standard is key for stops and frisks.
Okay, so warrants are the rule, grounded in probable cause and particularity, but, as Angela's notes point out, reality check. There are so many exceptions that warrants are often not obtained in practice.
That's the practical truth. Police can often act without a warrant in certain situations. These exceptions are critically important to understand.
Let's go through them. First up, the automobile exception.
A big one. Police can search a car without a warrant if they have probable cause to believe it contains contraband or evidence of a crime.
Why the special rule for cars?
Two main reasons. Their mobility, they can be driven away easily,
Yeah.
taking evidence with them, and the reduced expectation of privacy we generally have in vehicles compared to homes.
So probable cause is still needed, but not the warrant itself for a car?
Correct. Then we have the plain view exception, which we've already hit on. If contraband is in plain view, officer is lawfully present, illegality is obvious, they can seize it. No warrant needed because it's not even considered a search to see it.
Got it. What about administrative searches? Airport security, border crossings?
Right. These are searches conducted for regulatory purposes, not primarily to find evidence of a specific crime. Think airport screening, border searches, inspections of heavily regulated businesses like gun shops or restaurants.
The justification is more about public safety or national security.
Exactly. It's a different rationale, often involving lower levels of suspicion or sometimes no individualized suspicion at all, because the government interest is considered particularly strong in those contexts.
Okay. What happens right after someone is arrested? Can the police search them?
Yes, that's the search incident to a lawful arrest exception, or SILA. When police make a lawful arrest, meaning the arrest itself is based on probable cause, they can contemporaneously search the person arrested.
Their pockets? Clothing?
Right. And the area within the person's immediate control, sometimes called their wingspan or grab area.
Why? What's the purpose?
Two reasons. Officer safety to find weapons the arrestee might use, and to prevent the destruction or concealment of evidence that the arrestee might have on them or within reach.
Crucially, the arrest has to be lawful first.
Absolutely. If the arrest is bad, the search incident to it is also bad. Fruit of the poisonous tree, which we'll get to.
Okay, and the last big exception, the Terry stop and frisk. Always controversial.
Very, and it has two parts based on that Terry v. Ohio case. First is the stop, which is actually a brief seizure of the person.
The detention.
Right. Police can briefly detain someone on the street if they have reasonable suspicion that criminal activity is afoot.
And reasonable suspicion is?
It's a lower standard than probable cause. It requires specific, articulable facts that, taken together, would lead a reasonable officer to suspect that criminal activity might be happening or about to happen. It's more than a mere hunch, but less than probable cause.
So the stop is based on reasonable suspicion of crime. What about the frisk?
The frisk is a limited pat-down of the person's outer clothing. This is only allowed if the officer also has reasonable suspicion that the person stopped is armed and dangerous.
It's purely for weapons, for officer safety.
Exactly. It's not a search for evidence.
Yeah.
If the officer feels something during the pat-down that they reasonably believe is a weapon, they can retrieve it. Angela's notes give an example, suspecting someone is breaking into buildings.
Right. They might have tools like crowbars.
Which could be used as weapons. That specific articulable fear could justify the limited pat-down for safety.
Okay, that clarifies the exceptions. Now, what happens if the police mess up. If they conduct an illegal search, violating the Fourth Amendment.
That brings us to the exclusionary rule, a cornerstone of Fourth Amendment enforcement and very controversial.
What does it do?
Simply put, if police seize evidence illegally in violation of the Fourth Amendment, that evidence generally cannot be used against the defendant in court. It gets excluded.
Why is it controversial?
Because, as Justice Cardozo famously put it sometimes means the criminal is to go free because the constable has blundered.
Yeah.
A guilty person might avoid conviction because of how the evidence was obtained.
That sounds tough to accept. What's the argument for the rule?
The main argument, championed by Justice Brandeis, is about deterrence and judicial integrity. Brandeis said, if the government becomes the lawbreaker, it breeds contempt for the law. The rule is meant to deter police misconduct by removing the incentive to violate rights. If the evidence gets tossed, why bother searching illegally? It also keeps the courts from becoming complicit in illegal government actions.
So it's about holding the government accountable, even if it means a guilty person might walk.
That's the trade-off, essentially.
Ah.
And building on this, we have the fruit of the poisonous tree doctrine.
Sounds bad.
It extends the exclusionary rule. Not only is the illegally seized evidence itself, the poisonous tree, excluded, but any additional evidence derived from that initial illegality, the fruit, is also excluded.
Example.
Police illegally search a house and find a key to a locker. They use the key to open the locker and find drugs. Both the key, direct evidence from a legal search, and the drugs, derived evidence, the fruit, would likely be excluded.
It prevents the government from benefiting indirectly from the initial mistake.
Precisely. But, like everything in law, there are exceptions to the exclusionary rule, too. Angela's outline lists several.
Ways evidence might still get in, even after an illegal search.
Yes. The big one is the good faith exception. If police conduct a search relying in good faith on a search warrant issued by a judge, and that warrant is later found to be invalid.
Through no fault of the police officer who applied for it.
Right. If the officer reasonably believed the warrant was valid, the evidence might still be admissible. The idea is that excluding the evidence wouldn't deter police misconduct if they thought they were doing everything right based on a judge's order.
What else?
There's an exception for violations of the knock and announce rule. Generally, evidence won't be excluded just because police failed to knock properly before entering with a valid warrant.
Interesting.
Illegally obtained evidence can sometimes be used for impeachment to challenge the defendant's credibility if they testify differently at trial. It can't be used to prove guilt directly, but it can be used to show they're lying on the stand. Then there's the independent source doctrine. If the evidence is also discovered through a separate legal source, completely independent of the illegal search, it can come in.
Like, they find it illegally, but someone else was already on the way to finding it legally.
Sort of. Or they had totally separate information leading them to it. Closely related is the inevitable discovery doctrine. If the police can show they would have inevitably discovered the evidence through lawful means anyway, even without the illegal search, it might be admitted.
Like, they were already conducting a grid search that would have found the body, even though someone found it illegally first.
That's the classic example. And finally, the attenuation doctrine. If the connection between the illegal police act and the discovery of the evidence is so weak or interrupted by intervening circumstances, the taint of the illegality might dissipate, allowing the evidence in.
Wow. Lots of ways around the rule.
It's complex, balancing deterrence against getting reliable evidence before the court.
One last structural point. How does this apply to states? The Bill of Rights originally just limited the federal government, right?
Correct. But through the doctrine of incorporation, specifically via the Due Process Clause of the 14th Amendment, most provisions of the Bill of Rights, including the core protections of the Fourth Amendment, have been applied to state and local governments as well.
So your local police department is bound by the Fourth Amendment just like the FBI is.
Exactly. It ensures a baseline of federal constitutional protection across the country.
Okay, that's a lot of doctrine. Let's try to apply it with some quick scenarios, like bar exam, multiple choice questions. Ready, listeners? Pause and think after each one.
Let's do it. Scenario 1. Police use a thermal imager from the street to scan a house for heat patterns, suggesting marijuana grow lights inside. Is using the thermal imager a search under the Fourth Amendment?
Think about Katz and technology not in general public use.
The answer is yes. The Supreme Court held in Kylo v. United States that using sense-enhancing technology not in general public use to get information about the inside of a home that couldn't otherwise be obtained without physical intrusion is a search. It violates the reasonable expectation of privacy in the home.
Okay, scenario 2. Police lawfully arrest someone for shoplifting on the street. They then search the person's car, parked 2 blocks away. Is this search valid as a search incident to lawful arrest?
Consider the wingspan rule.
The answer is no. A search incident to arrest is limited to the person and the area within their immediate control at the time of the arrest. A car 2 blocks away is nowhere near the arrestee's immediate control. They'd need a different justification, like the auto exception if they had probable cause for the car itself.
Scenario 3. A reliable known informant tells police a specific red car at a specific address contains illegal guns. Police go there, see the red car exactly as described. Do they have probable cause to search the car?
Think about informant reliability and corroboration.
The answer is likely yes.
Yeah.
While an anonymous tip alone often isn't enough, a tip from a known, reliable informant, corroborated by police finding the specific car at the specific location, usually does establish probable cause. If they have probable cause, the automobile exception allows a warrantless search.
Scenario 4. Officer lawfully enters a garage responding to a domestic disturbance, sees a baggie of white powder, instantly recognizable as cocaine, on a workbench. Can the officer seize the baggie?
Check the plain view requirements.
The answer is yes. The officer is lawfully present, the cocaine is in plain view, no manipulation needed, and its incriminating nature is immediately apparent. Meets all elements of the plain view doctrine for seizure.
Last one, scenario 5. Police illegally search an apartment and find a diary detailing bank robbery plans. Later, an independent informant gives police the same robbery plans. Based only on the informant's tip, police get a warrant and find evidence at the bank. Is the bank evidence admissible?
Think about where the information for the warrant actually came from.
The answer is yes under the independent source doctrine. Even though the diary is found illegally, the evidence from the bank was obtained via a warrant based on information from a completely separate, independent, lawful source, the informant. The illegal search didn't taint the evidence obtained through the independent path.
Great examples. Now, for the main event, a bar exam style essay question. This one has 3 parts. Let's break it down.
Okay, here's the setup for all parts. Police get an anonymous, uncorroborated tip that drug dealer gave sells drugs from apartment 2B. The tip is vague, just the name and address. Officers go to the hallway outside 2B, hear faint music. One officer uses a super-sensitive microphone against the door, hears clear talk of drug deals inside. Using this info, they get a warrant, search 2B, find drugs and cash.
Part A. Did using that microphone against the door constitute a search under the Fourth Amendment? Let's use IRFAs. Issue. Was the use of the sense-enhancing microphone against the apartment door a Fourth Amendment search?
Rule. Fourth Amendment protects against unreasonable searches. A search occurs with physical intrusion or violation of a reasonable expectation of privacy, Katz. Highest expectation of privacy is in the home. Using technology not in general public use to get information from inside a home that couldn't otherwise be obtained without intrusion is a search, Kylo. Analysis. Apartment 2B is Dave's home. Highest protection. He has a reasonable expectation of privacy and conversations inside. The microphone was sense-enhancing tech, not in general public use. It gathered info, conversations, from inside the home that wasn't audible from the public hallway without the tech. This intruded on Dave's reasonable expectation of privacy.
Conclusion, Part A. Yes, the use of the highly sensitive microphone constituted a search under the Fourth Amendment.
Okay, Part B. Now assume the microphone use was an illegal search. The officers used the info from the mic to get a warrant from a neutral magistrate. They honestly believe the warrant is valid. They search and find the drugs cache. Are the drugs and cash admissible?
Issue. If the warrant was based on info from an illegal search, is the evidence admissible under an exception, like good faith?
Rule. Exclusionary rule bars illegally obtained evidence. Fruit of the poisonous tree doctrine bars evidence derived from illegality. For E&T, the good faith exception allows evidence obtained via a warrant if officers relied in objective good faith on the magistrate's issuance, unless certain conditions apply. For example, magistrate misled by info, officer knew should have known was false, magistrate abandoned neutrality, affidavit lacked probable cause so badly no reasonable officer would rely on it, warrant facially deficient.
Analysis. The mic surveillance was illegal, per assumption. The info from it was used for the warrant, making the warrant an evidence fruit. But officers got the warrant from a neutral magistrate and honestly believed it is valid. This points toward the good faith exception. We'd need to check if any of the invalidating conditions apply. The facts don't suggest the officers lied to the magistrate or that the warrant was facially bad. The key is whether the affidavit, even with the illegally obtained info, was so lacking in probable cause that reliance was unreasonable. Here, the illegally obtained info did describe drug deals, likely providing probable cause on its face, even if improperly obtained. So a reasonable officer might rely on the magistrate's issuance.
Conclusion, Part B. The drugs and cash are likely admissible under the good faith exception, assuming none of the invalidating circumstances like lying to the magistrate or obvious lack of probable cause in the face of the affidavit were present. The officer's reasonable reliance on the magistrate's approval of the warrant saves the evidence.
All right, Part C, change of venue. Assume Dave operates from a large, open field on his rural property. Police fly a drone lawfully at 500 feet over the field, see rows of marijuana. They land the drone, enter the field without a warrant, seize the plants. Was the drone observation and the warrantless entry seizure permissible?
Issue 1. Was the drone observation from 500 feet over an open field a search? Issue 2. Was the subsequent warrantless entry and seizure of the plants lawful?
Rule: open fields doctrine. No reasonable expectation of privacy in areas beyond the curtilage, even if privately owned. Oliver. Observations from public navigable airspace are generally not searches. Plainview doctrine allows seizure of contraband if officer is lawfully present and criminality is immediately apparent, but it doesn't authorize a warrantless entry onto property to make the seizure. Warrantless entry and seizure require a warrant or an exception. For example, exigent circumstances.
Analysis. The drone at 500 feet over an open field, not curtilage, is likely okay. It's consistent with the open fields doctrine, and observations from public airspace generally aren't searches. Dave has no reasonable expectation of privacy from aerial observation of his open field. However, observing the plants doesn't automatically justify entering the field and seizing them without a warrant. The officers entered private property without a warrant. Plain view allows seizure from a lawful vantage point, but doesn't justify the initial warrantless entry onto the field itself. No exigent circumstances, like risk of destruction, are mentioned.
Conclusion, Part C. The drone observation was likely not an unconstitutional search, but the subsequent warrantless entry into the open field and seizure of the plants was likely unconstitutional, as there was no warrant and no apparent exception justified the physical intrusion onto Dave's property to seize the items. They saw it legally, but needed a warrant to go get it.
Whew. That covers a lot of ground. It really shows how these doctrines interact.
It absolutely does. And that brings us near the end of this podcast on the Fourth Amendment. We hope exploring these details has been helpful for your studies or just your understanding of this vital right.
And we really have to thank Angela again. Her comprehensive con law notes made this detailed discussion possible. The clarity is just fantastic.
Truly invaluable. Now, just a few quick housekeeping points before we wrap up completely.
First, remember, Angela is a law student, working hard just like many of you. She's not a practicing attorney yet, hasn't passed the bar.
Right. And neither Angela nor this podcast is providing legal advice. Please don't take it that way. This is purely educational.
And while AI, like us, is a great tool, it's not a substitute for the hard work of studying for the bar. Use this as an aid, a way to reinforce concepts, not a shortcut.
Yeah, this should definitely supplement your main study routine, not replace it.
Also, AI isn't perfect. Sometimes we make mistakes. Angela does her best to ensure accuracy based on her notes, but oversights can happen. It's all part of learning.
And remember, this whole podcast series is an academic, non-commercial project for Angela. It's purely for education, driven by her passion for the subject.
Finally, and importantly, if you are listening while driving, please prioritize safety. Keep your eyes and attention on the road.
Seriously, don't cause a tort while listening to con law. Stay safe out there.
If you want to reach Angela, again, it's podcast@studyforthebarinyourcar.com for general inquiries, or hello@legalwriterandlawclerk.com for her freelance clerk services.
And now, as is our tradition, a cheesy Fourth Amendment joke. Why did the police officer bring a ladder to the bar?
Uh-oh, I think I might know.
Because he heard the drinks were on the house and he needed a warrant to search for them.
Yeah, okay, that's pretty good.
We're your AI hosts, Claude and Maude, signing off.
We'll see you on the next podcast where we'll tackle the Fifth Amendment.
Thanks for listening. Bye.